Andrew Bailey, appearing telephonically. Good morning, Your Honor.
Okay, good morning.
Good morning, Your Honor. Kyle Hirsch, the law firm of Brian Cave, on behalf of the defendants.
Okay.
Your Honor, this is a motion to dismiss the third amended complaint filed by Mr. Bailey. I will try to make my presentation as I can, and I appreciate the court's accommodation to my schedule hearing coming up in Judge Nielsen's courtroom. Your staff was very accommodating for that.
All right.
This is the third amended complaint by Mr. Bailey, who is not represented by counsel, and this court has indicated that his failure to be, or refusal to be represented by counsel has created some difficulties, at least with respect to some of the pleading issues. One particular that he faced in reviewing the third amended complaint, frankly, was trying to get a handle on exactly what the cause of action, the facts that were supposedly supporting those causes of action. But the motion to dismiss, I believe, handled that issue the best that we could based on our understanding of the third amended complaint. As the court may recall, there was a stay relief hearing about a week. An order's been uploaded, and I'm having that sent to your chambers because I think it may have gone to Judge Baum since he's on the administrative case. So that's being sent over to your by email today. But I do want to make sure that's clear because that may have an outcome on the original motion to dismiss that was filed on the third amended complaint, and also our presentation will address how that may impact it as I move along.
All right.
I think the court's probably familiar with the facts, so I'll skip that. The first cause of action is asserting lack of standing, that defendants lack standing to enforce the note or deed of trust. And it's a request for declaratory relief. As set forth as a matter of law, MERS is, as nominee of the beneficiary under the deed of trust, may foreclose. This court granted stay relief, and in so doing, confirmed that on a summary basis, there was a sufficient that defendants do have standing. The deed of trust confers upon the defendants the authority to foreclose on its own terms. So there's no need for a valid note or the show me the note theory, as it's been called. The deed of trust has authority within the four corners of that document. Accordingly, the allegations that are implausible and accordingly dismissal is appropriate. The second cause of action, which is void contract, is based on the legal theory that there was no meeting of the minds. In fact, there was a meeting of the minds. Plaintiff agreed to be bound by the contract wherein he would borrow $425,000 and pay it back on a certain repayment schedule with interest secured by the property. And the defendants also agreed to those terms. Plaintiff claims that he had no idea that the loan would be express terms of the deed of trust, which contain a provision authorizing the sale of the loan. And the legal theory behind this cause of action, which is the secret intentions of the defendants, is not recognized under Arizona law as a basis for voiding a contract. So long as the parties demonstrate that they had an intent to be bound by the contract, it's an enforceable contract. Accordingly, the second cause of action is ripe for dismissal. The third cause of action is for fraud, false representation, and predatory lending. Again, there are some fatal flaws in the method in which this cause of action was pled. First, it's pled under a criminal fraud statute under which this court does not have jurisdiction. In addition, the allegations are unsupported by the facts that are alleged. The defendants made no representations at the time this loan was entered into. The party at the time was Countrywide Bank FSB and Countrywide Home Loans Inc. that were involved in this loan at the time the loan was entered into. Those are not named defendants in this case. So the fact that there may have been representations does not support any cause of action against the named defendants. Finally, there's threadbare recitals that fail to satisfy the Iqbal Twombly standard. For example, there's a This court has already found that the defendants have standing. They are the holders in due course. The note and deed of trust are valid. There's no enforceable contract. It failed as a matter of law. And in short, the causes of action that are pled failed, and therefore the quiet title action must also fail because preventing defendant from maintaining his interest would be. Finally, the fifth cause of action asks for injunctive relief. There has been a stay relief order entered, so the fact of irreparable injury.
Wait, let me stop you. It hasn't been entered.
I'm sorry. The court has granted a motion for stay relief, and the order is pending. I appreciate the correction. But the fact that the defendants are entitled to commence foreclosure proceedings does not create irreparable injury. Moreover, that injury has been found is justified on the merits. The balance of hardships, if an injunction were to enter, would favor or would the defendants greater than it would help the plaintiff in this case, given that the defendants have established their right to enforce the note and the deed of trust. And there is no public interest to be maintained by Finally, there's technical requirements for a temporary restraining order and a preliminary injunction that have not been met, which are in the motion. Accordingly, injunctive relief is unwarranted, and dismissal of the cause of action and the complaint in its entirety is warranted. This motion was filed as a motion to dismiss. This is the third amended complaint, third time the plaintiff has had an opportunity to properly plead what he believes are legal theories that justify relief. The defendants have incurred substantial in filing motions to dismiss. This court has recommended that the plaintiff find legal counsel to assist him in properly pleading a complaint, which the plaintiff, for whatever reason, has not done. The defendant should not be continuously hauled into court on facially insufficient pleadings, and accordingly, dismissal with prejudice is appropriate. Unless the court has other questions, I will relinquish the podium to the plaintiff.
Okay, Mr. Bailey?
Good morning, Your Honor. Thank you. Let me see. This is a rather large series of statements to respond to, so I'm not quite sure how to approach that. Firstly, I will simply state for the record that I stand by my pleadings. I believe I have laid them out in good detail. They may lack certain things procedurally, as Mr. Hirsch just said, with regard to the requirements for the TRO and for the quiet title action. But I stand by every statement I have made there, and I believe that if we do get to proceed to discovery and that we have a hearing and that I'm able to present my expert witness, that all of those things, including a full accounting, which will show that there have been third-party payments made on the obligation, that my allegations will turn out to be justified. I think perhaps the best approach might be, Your Honor, just to, if you would ask me whatever questions you feel, what is lacking in terms of your understanding of what I'm presenting.
Mr. Bailey, we've been through this before, and I think this is something that you need to move forward with and articulate your argument, because I've previously outlined on the record at a number of hearings my concerns. And I'm not sure that you've really addressed those concerns. Your response, for instance, isn't really a response. You keep going back and relying on information or decisions, et cetera, that I've already told you that there's a problem with. So this is really